Hello, everyone, and welcome back to the preparation for the CLAT examination. We've been discussing in this particular lecture series about the important aspects that needs to be covered when you are preparing for a CLAT examination. And specifically talking, we have confined ourselves towards the legal reasoning syllabus of your CLAT examination. In this particular lecture series, we have discussing all the important legislations and lectures that are going to be helpful for those who are preparing for CLAT examinations as such. And therefore, it becomes an important point of discussion that how the things needs to be prepared, what are the things needs to be done if you're planning to give your CLAT examinations in the near future. When you talk about CLAT as such, if we talk about the examination as such, this examination is much more not about grasping and learning what exactly the law is, but it actually tests your analytical skills, that to what extent a student or a CLAT aspirant is able to bear the pressure, because the time duration that is allocated when you talk about CLAT examination in totality is 2 hours, that is 120 minutes. And within this time frame of 120 minutes, a CLAT aspirant is supposed to answer 150 questions, out of which there are lengthy paragraphs. So those lengthy paragraphs are actually not going to test you, actually they are not to test the knowledge of the candidate, but to see to that what extent the candidate is able to read the passages very efficiently and correctly, and the principles that they have understood, either by themselves or through these type of lecture series, or by learning by themselves, that these principles will be coming up handy to figure out that which is the correct answer and which is not the correct answer. But if you talk about on a general perspective, this CLAT examination is not going to actually test to what in-depth knowledge you have, but rather the knowledge that you have gathered after completion of your 12th class, after completion of your intermediate, that what exactly is your approach towards problem solving. How do you approach towards a problem and how do you solve it? This is perhaps the most important thing that a CLAT examination is going to test, because if you are planning to become a lawyer in future, or you want to join the law fraternity, it is perhaps very important that you are a problem solver and you know how to tackle the things, how to bear the pressure. So these competitive examinations are actually made in order to test that particular skills of yours. People, or if I say correctly, the CLAT aspirants are much more inclined toward learning the law and not understanding what exactly needs to be done in regards to your CLAT examinations and such. As we talk about the current lecture series that we are actually right now focusing over, as you know that we have already completed with our contract acts, we have completed that particular legislation. We have talked about the Constitution of India also. We have discussed the criminal laws as well as we have discussed the law of torts. So these subjects that we have discussed so far are not something that we can study in maybe 10 or 15 lectures or 20 lectures. These are commentaries. There have been commentaries over the law of contracts. There have been commentaries over the Constitution of India, the law of torts. But when you talk about the CLAT examination as such, you are not supposed to go and study in depth each and everything whatsoever has been there in the Constitution, whatsoever has been there in the other legislation. We be specifically talking about the contracts, we be specifically talking about the law of torts and the other subjects which are attracted in regards to your syllabus of your CLAT examination. The main focus, the main agenda one should always keep in mind whenever they are preparing for CLAT examination, specifically CLAT examination, is what exactly is their reading speed. to what extent can they be able to read the passage efficiently and as able to apply their mind immediately once they read the particular paragraph. Because as you know, if you're talking about 150 some odd questions and 120 minutes to answer those questions, and in that particular answer, what you need to do is you just need not only study it, study the passage, but also you have to study the questions, and then you'll have to mark it. So if you talk about one question, then it will take a rough around 33 seconds. For one question, you will be only allotted 33 seconds to answer that particular question. And when you talk about the pattern, there will be one passage on which you will have around 5 questions. So meaning which if you multiply 33 by 5, you will get a rough amount of around 2.5 or maybe close to 3 minutes to answer 5 questions. So that means you need to have very efficient reading speed as well as immediate application of the rules that you have studied through your preparation of your CLAT examination. That examination specifically is going to be tough for those who have studied the law. They have thoroughly studied the law, but they have not practiced the MCQs. The previous year question papers becomes very important, not only for CLAT examination, but also for other examinations. Because in that particular examination, it is important to understand that what exactly is the need of that examinations as such. It is not about learning the law. Students have always been asking me today itself when I was having a word with some of the students. They asked me, sir, what exactly does the CLAT consortium looks forward to whenever they are making the question papers? So it is not at all about learning the law, because that is something you are supposed to do after you have cleared the examination. So what you have to do, and obviously some important legislations or some important aspects or some important rules should be known, and seeing the competitive aspect, often the questions being asked from these legislations. But truth be told, that the questions or the rules will not be asked from very depth, or maybe case laws which is not very famous, or maybe a provision which is not very useful. But there will be questions from the general perspective which are important for a layman also to know. For example, what is exactly a fundamental right? Every citizen of India should know what exactly is fundamental rights. What exactly is the definition of state under Article 12? Every student should know. Every citizen should know. What exactly do we know about contract? How do we make a contract? Every person who is going to start a business or want to have an agreement or want to do any transaction, in order to keep their rights intact, it is important to know how exactly the contract works. To what extent a person is allowed to do a certain act, to what extent he is not allowed to certain act, what is right and what is wrong, what is legal and illegal, what is crime, is something which a person will obviously be able to know after he has studied the Indian Penal Code. So the criminal laws come in handy in order to understand that whether this particular action or particular act may be considered as a crime or not. Because if you talk about the latent terminology which is being often used and often asked in your CLAT examination also, that which says that ignorance of law is not an excuse. Ignorantia non excusat clause. So what does that mean? It means that a person is not supposed to ignore the law. Ignorance of fact can be excused. If you don't know something, then it can be excused. But if you don't know the law, that is something which is not acceptable. You cannot say to if you do something wrong that I wasn't knowing that it is wrong. And there has been case laws also the same, which suggests that ignorance of law is not at all an excuse. So the CLAT examination is not going to ask you that what exactly in this particular provision has been written. because that is obviously, I've just informed you, it is something that you will be going to study in your college time when you get selected in CLAT examination and you are going to locate one national university, and then you started studying the law. Then what exactly the provisions are, what exactly, how do you need to study the law, everything will be taught to you again. But when you talk about CLAT examination, efficiency and quick application of mind is important. And how do we do that? Question is, how do we do that? And the simple answer is thorough practice. As you know that there is a famous statement which says that practice makes a man perfect. In the same way, it is very important to practice the mock test, to practice the previous year question papers. And in order to practice those question papers, first you need to at least know a little bit of concept. Once you have understood the concept, all you need to do is you need to read the passage, see through it that what concept has been made applicable in that particular paragraph. And then you will be able to figure out that, okay, if this is the question that has been put forward in front of me, the answer would be this. You will be given 4 options, then you'll have to mark the same. But until unless you are not practicing efficiently, even if we have lectures for maybe on all the relevant topics that could be asked in your question paper, you will not be able to attempt the questions in large. Because if the reading speed is not fast, if your analyzing speed is not fast, then it becomes difficult. And why is it so that the CLAT aspirants want the CLAT examination, the CLAT consortium wants that there should be efficiency while reading and efficiency while analyzing? Because once you get into the career of law, it is all about reading lengthy judgments. It is all about reading 300, 400 papers of a documents paper within maybe 2 hours or 3 hours in order to understand that what exactly has happened in that. And for that, you need to make sure that your reading speed is very high, your analytical skills are very high. And that is what is being tested in your CLAT examination. So keeping that thing in mind, I have been continuously throughout the lecture series, which has now been almost a month or so since we have been studying together, that what exactly through this portal of SATHEE, that what exactly is the important areas of law that is going to be there in your CLAT examination. We have always been focusing over one important aspect, and that is the 3 principles which I've already informed you earlier lecture series also. That practice, retention of the principles, and persistency, continuous practice. It is not like that if you'll practice for maybe 1 day or 2 and then for 4 or 5 days you're not practicing, then it is going to be helpful for you. The reason why is it important for anybody or any student to prepare the examination in such a manner that they are able to qualify and they are able to succeed in this examination is obviously maintaining the discipline and being consistent and practicing every day whatsoever you have studied. Once you have understood the concept, the most important thing is obviously understanding the concept. Without understanding the concept, it becomes perhaps impossible for any of the aspirants to clear the examination, because even if your speed is good enough to tackle all the questions that will be put forward in front of you, if you don't know the concept, then even if you can read everything, but you won't be able to write the correct answer. So first, understanding the concept and understanding the principle is perhaps the most important portion. Then comes practicing, that once you have understood the concept, you are practicing it continuously. And once you have been able to practice in such a manner that you are able to read and tackle almost every question that been put forward in your CLAT examination, and you have known the principles, you have to consistently do it. Because it is not like that for 1 or 2 days or maybe a week or 2 you have been consistently practicing, and then you feel like that now I have gained confidence and I will be able to solve the questions, and then you sit idle, just revise your principles. That's not going to work. Because the moment your mind has a psychological belief that once you start doing anything and you practice and practice and practice, it becomes a daily routine. It becomes easier for you to do it. So that is why persistency and being continuous and being consistent is very also important. Okay, So this is what I wanted to share with you all, that what exactly is the most important key in regards to the preparation of your CLAT examination. It is not like that I have not explained you these things in earlier lectures, but I always want the CLAT aspirants and whomsoever is preparing for this CLAT examination, they are able to analyze that all these concepts are going to be repeated in your college time period. Every concept that we are studying so far. But what is not going to be repeated, and what is that thing that is going to be tested in your CLAT examination, is your reading speed, your analyzing speed, and then obviously your problem solving skills. And that is why the consortium has prepared the paper in such a manner that first you'll be asked English questions, where which your grammars, whether you know what exactly the words are, how your vocabulary is, because you would be, if you have happened to read the judgments, you would see that there are lots of important words that is being used, the legal terminology which is being used in your judgments, in your drafting of plaints. Plaints means the application that you submit in the court, and then what should be the reply of that particular application if you are the opposite party. So for that you need to express yourself. And how would you be able to express yourself? Only when you have good amount of words with you. Once you are able to use that words to showcase to the world that okay, this is what I want to express, then only you will be able to uh, make the judge or make the court believe, or uh, let them know that what exactly has happened. So that is why English becomes a very important topic in your CLAT examination. Correct? Okay. Then you will be asked questions from legal reasoning. That is the concepts or the principles that is applicable in regards to the law. And why do we ask that? Because the student should be able to understand a little bit, or they are able to understand some basic things that even a layman is expected to understand. I just informed you, like we are talking about a CLAT examination, then we are talking about not only the law, but also the basic common sense things, like what is fundamental rights, what is human rights, what is directive principles of state policy, and what exactly is executive, what exactly is judiciary, what exactly is legislation, how do we make a contract, what exactly is a crime, what is a punishment, and if we talk about family law, then what exactly, how do we solemnize a marriage, what are the conditions of marriage, who is competent to marriage, and whether we follow the same principles for all the religions, whether we follow different principles for different religions, what exactly is the principles in regard to this particular religion, that particular religion. So these things a person is expected to know, because these things are going to be helpful not only in their examination but in their longer journey as well, in their life also. So that is why whenever you are preparing for CLAT examination, please never ever think that just revising the subjects that we have studied is going to be benefiting you. It is not about the subject, but it is rather about the practice. With this, I would like to start our today's lecture. And the reason for I being focusing over how to prepare and what to prepare is to make you people understand that CLAT examination is something where which, if you are able to succeed, you are going to spend 5 years of your life in a rigorous regime where which you will be asked to study a lot of judgments, to study a lot of case laws. You are expected to read a lot during your preparation, during your career molding phase. And for that, it is important to see that whether you have that capability or not. And that is why this examination is being conducted. So I suppose you people have now understood that what exactly is the need of this examination, and why is it so that these type of things has been asked. And same goes with some people might have some doubts. That's okay, I have understood the legal reasoning portion is there, the logical reasoning is there, in order to find out that whether people are able to figure out what exactly is the logic behind this particular thing. The way I've just explained you that what is exactly the logic, the same thing is there in regards to your logical examination. But some people might have this particular thing in mind. So then what exactly is the need of studying quantitative aptitude? where which you are asked to solve questions like mathematics questions like what will be the time duration, what will be the speed, what is the average and everything. Because when you talk about law examination, it is not only confined towards the law. There are things that will be putting in front of you when you talk about examinations, when you talk about calculating the amount of punishment that has somebody been granted, that what should be the fine, and there are a couple of people who have been involved in a lot of crimes together, then what exactly should be the fees. So that mathematical calculation will also be there. It is not only confined like, okay, law is there, but to no mathematical calculation will be there. Mathematical calculation will also be there when you are going to figure out that, okay, for what time period this particular person has been in jail. How are you going to figure out? 1997 cases, if you'll be given and you'll be asked, okay, the person is inside the jail, or maybe a person has been absconding since then calculate the time period still when he was not present. Because there is a certain time limit when you can approach to the court and seek justice. It is not like that a person who has been a victim of a certain crime in the year of 1960 or 1970 now turns up and comes to the court saying that, sir, I was a grieved person and I was a victim in a particular incident that took place on that date. And now I want to get relief over the same. The court will say that we cannot allow you to, because you are not within that particular limitation period. So how you are going to calculate that this is the time period? How you are going to see that what should be the average amount that should be charged? You will be if you tackle the family law, if you talk about maintenance, that what amount of maintenance should be provided to a particular person, what amount of share should be given. That is something where which a little bit of mathematics will also come into play. And that is why mathematics has been involved in your CLAT examination. So in this particular series of CLAT preparation, we have been focusing over the different subjects. I have just informed you about the same. In our previous lecture series, we were actually discussing about an important topic, that is the Hindu Marriage Act. And we have completed the Hindu Marriage Act in regards to your CLAT examination, where which we have discussed about the important areas like what exactly is a Hindu, to whom this particular legislation will be applicable, when this legislation came into effect, when it was enacted, and then what are the important definitions, what exactly is a subpender relationship, what exactly is prohibited degrees of relationship, what are the important requisites of a marriage, what are the grounds, and what are the areas on which a person can seek divorce if they don't want to continue for marriage. Can they give divorce immediately? Can they not give divorce immediately? Whether there are same things applicable for a male, whether there are different things applicable on male. All these things has been mentioned and codified in the Hindu Marriage Act. That things we have already studied. We have studied the ceremonies of marriage. We have studied the conditions of marriage. We have studied what exactly is a void and voidable marriage, and what exactly is a valid marriage. We have studied about who exactly is a Hindu, to whom these laws will be applicable. We have studied what exactly is a divorce, what are the grounds of divorce. Can a divorce be by mutual separation, or there can be only some grounds? What are those grounds? All these things we have already studied. And from today's lecture onwards, we are going to study perhaps the very important topics when you talk about the rights of a particular immovable property. So that is something where which we would be starting our lecture with one example. And for that, I suppose the screen is visible to you all. We are going to start with the just give me 1 minute. So we are going to start with the Hindu Succession Act. So when we say again Hindu, it means it is only applicable to Hindus. And what is Hindu? And the definition we have already studied, that who is constituted to be the Hindu. Hindu will include what? It will include Jain, Sikh, and Buddhist. And it will exclude Muslims, Christians, Parsi, and Jews. And there are other sects that we have already studied. So this was just to make you people remind you people of what exactly is a Hindu and what exactly has been studied. So the same definition that was there in your Hindu Marriage Act, the same definition will be used for your Succession Act also. Now, what exactly do we understand by succession? First, let's try to understand that in a very crystalline, clear manner, because the questions that will be put in front of you will be, some questions will also be there from your Hindu Succession Act. So let's take an example for you guys. This is a person X. Okay. This person has 3 properties. Okay. This is one house. This is, I'm so sorry for my drawing, but I'm just trying to explain you guys that what exactly is the situation here. Okay. And he has a land also. Okay. So he has a land also. Let's assume that this is the gate for your better understanding, and this is the pathway. Okay, for your better understanding, let's make it in such a manner. Okay, so this is how the lands look like. This is the gate, and so this is one property. This is property A. This is property B. And this is property C. This person X works to the best of his capability in order to earn this house, A house, this is another house B, and a land C. Okay. So now this person has this number of property. And he was married to Y. Y is a woman to whom he was married. Okay. So this will be now, he is now the husband and she is now the wife. And after the marriage, with Y, X was blessed with one daughter. This is X daughter. One son. This is X son. And let's take example, one more daughter. Okay. X had one brother, and obviously they had one father and one mother. Okay. So let's try to understand this family first. So this was X. He had a father and a mother, and he had a brother also. He had a wife also. And then he had 3 children, 2 daughters and 1 son. So now you have understood that this is one person. We are trying to understand the story here so that you will be able to understand what exactly succession means. Now we'll understand that this particular person X has worked hard and he was able to establish his empire by purchasing one house A, another house B, and another area or land, or maybe let's take this as a company C. Okay, company C. Now on a fateful day, what happens is that X dies. X dies. Now he is left with a widow. Now wife, obviously when the husband dies, the wife is now the widow. Okay. Father died before the death of X, but mother is still alive. Brother is still alive. One of the daughter passed away earlier when she was young. Now this daughter is alive and she was married to a person E. Let's take the example. She was married to E. Okay. And then he has a son who is still alive. So if we talk about this particular family of X, then on the death of X, he had how many people who were living? So father has died. The father is no more. Mother is alive. Wife is alive. One daughter is alive. One son is alive. One daughter is alive. One brother is alive. Okay. And after the marriage, obviously now he has a relation with E also, who happens to be his son-in-law. So son-in-law is also alive. Now this person has, after his demise, the first and the foremost question that will be put up in front of these people is in regards to this particular 3 properties which was owned by X, that how this property will be divided to M, that is the mother, to the widow, to his son, to his daughter, to his brother, and obviously to his son-in-law. Whether everybody will be getting the shares from the property of A of X, which is A, B and C, these 3 properties A, B and C, A, B and C property of X, how will it be segregated between these people who happens to be the survivor or who happens to be the hire of Mr. X? So this is something which is a common thing whenever you talk about Indian societies, since we have a large amount of big families. So this obviously happens that there is a brother who is alive, there is a widow after the demise of a person. And it also can be opposite of X. Instead of X, in the whole story, it's instead of X, it can be Y also. That Y, a woman, has 3 properties, A, B and C. She happens to marry a person X, and Y had a brother, and Y, from after marrying X, had 2 daughters and son. So the same story for X goes for Y also. So it is something which is gender neutral. Okay, for Hindu Succession Act, it is gender neutral. So how the property will be segregated, how the property will be divided, that is something which is in question. The very first thing you need to understand that this property A, B and C shall be given to the survivors. Survivors means the people who are alive when at the time of the demise of X and is related to X. So now it is clear that the property will be obviously be given to the survivors. But now the question is how you are going to divide the property. Whether is it possible that if the mother is alive and the widow is alive, then should the properties also be given to the son, daughter, and one more important question, to the brother also, to the son-in-law also? Or shouldn't it be given to the relatives of his father, meaning which his aunt, his uncle, to his brother only? So these questions that are coming up and that are being put up in front of us, how the property will be segregated in regards to X, whether it will be given to Y, B, brother and everything, has been answered under the act which is known as the Hindu Succession Act of 1956. This act is going to help you in understanding that if a person dies and if the person dies without having I repeat again. If a person dies without having a will, that is registered. Registered means a will that is registered and which has been made and signed in presence of two witnesses and without any force, coercion, etc. So if the will is registered, if the will is there and the will is registered and will has all the validity and legality that is present, then irrespective of how many relatives are present, daughter, son, brother and everything, if will is there, what exactly do we understand by will? When we say will, what we mean? It is somebody's choice. And when we say somebody's choice, it means that the person to whom these property belonged, A, B and C, wanted that the whole property A, B and C should be in the name of his brother. Okay, so X wanted that all the property, whether it is A, B and C, should be in the name of his brother, and that is what he writes it in his will. So if he has written that thing into his will, that I want that my property A, B and C after my demise, it will be given to my own brother, to my only surviving brother, not to my widow, not to my wife, not to my daughter, not to my another daughter, not to my son, not to my mother, but rather to only my brother. And if he mentions that, and let's take another example, instead of B, X transfer in his will, transfer his property to some another unknown person. Let's take an example, his servant or maybe his driver, who had no relation with X from blood. But if he makes a will and he says that all my property after my demise will be given and will be transferred, and the owner will be my servant or will be my driver or will be my friend or will be some another person, P, Q, etc. Then after the demise, and if it is proven and it is shown that the will is a legal will, means it has all the important aspects that needs to be completed. It has the signature of two witnesses. It was made without any contravention like coercion, force, etc. And it has free consent. That is, it was not by force that it was done. Then that will have preference over anybody's demand. So irrespective of Y claiming that this property should be given to me, B is claiming that this property should be given to me, son and daughter coming up and putting up this particular thing that this property should be given to me, that will not be entertained. Whatsoever has been mentioned in the will, whatsoever has been mentioned in that particular will to whom this particular properties will be transferred. And it is not like that that Mr. X can only make one will where which he has to segregate all the properties. He can make 10 wills. He can make 20 wills. He can make 100 wills. But only that will which is the latest one before his demise will be taken into consideration. For example, X made a will on 31st of May 2020, and then X made another will on 20th of June 2021, and then in the month of August 2021, X died. So if the X dies, then this will, if it is registered and follows all the important requisites that needs to be there when you talk about a will, then this particularly will be the will that will be taken into consideration. And if it mentions that the property be segregated to this person, then it will be segregated to that person. And this particular will that was created earlier will not be taken into consideration. Okay. So I suppose you have now understood that if a person has some property and he has made a will that is a legitimate will, then all the property will be transferred to that particular person or to that organization or to that institution that has been enumerated in the will. So this is something when a will is present, and that type of transfer or that type of inheritance is known as testamentary succession, meaning which there is a testament, there is a statement of X willingness that after my demise, after I leave this world and move to heavenly abode, where to whom these properties which I have owned throughout my hard work and my life should be provided. And if he makes a will, then it is known as testamentary succession, because he has clearly told by his willingness in front of witnesses and a registered will that my property shall be segregated to these number of people or to this particular people, or my A property will be given to maybe B property will be given to S, and C property be given to M. So he can divide the property according to whatsoever his desires and his wills are in his will. So this type of succession, this type of inheritance of the property shall be considered as testamentary succession. So the person who gets the ownership has been mentioned and is according to the will of the person X who has died. So now this is something which was, everything was planned. Person X occupied a property. After occupying the property, he made a will. And in that will, he has mentioned that after my demise, the property shall be transferred to this and this person. And that type of succession is known as testamentary succession. Now, let's take an example which you people might be able to correlate. That X, the person X dies without making a will. So now the question will be that there are so many survivors. There is a widow, there is a brother, there is a daughter who has married to a person E who happens to be a son-in-law, there is a son present, there is a mother present. So how the property will be segregated? Whether Y will be getting some property, whether B will be getting some property, or is it that Y and B will be getting equal property, D and X will be getting equal property, or M will be getting more property, Y and B will be getting less property, and D and S will be getting lesser property, depending over the age, depending over their situation, depending over their condition. What exactly and how exactly the property will be divided in case a person has not been able to make a will? This is something that has been answered and explained in a very systematic manner, in a very systematic and a very crisp and precise manner into the legislation which is right in front of you. That is the Hindu Succession Act of 1956. And if the will is not present, if will is present, I suppose you have now understood that what exactly will be the repercussions. But if the will is not present, then how the property will be divided? That type of succession is known as anti-state succession. Okay, and these two differences you need to remember, because there will be a question that might be present in front of you whenever you're going to prepare for your CLAT examination, when you're going to give your examination, that if a person dies without leaving a will and the property has to be succeeded by the heirs, then what type of succession will it be called? Whether it will be called testamentary succession or it will be called intestate succession. Because there are chances that X dies because of heart attack, because of accident at that point of time, he was not able to make any will. Then how the property will be divided? It will be divided according to the legislation which is known as the Hindu Succession Act. If at all, I just forgot to tell you one thing, and that is, and I suppose you people were able to assume it also, that X is a Hindu according to the definition that has been enumerated under the Hindu Succession Act and also under the Hindu Marriage Act, and he has died without leaving a will. Then what exactly will be the procedure, to what extent the survivors will get the property, will be answered in the Hindu Succession Act of 1956. So this is the gist of the story, and this is what we are going to study in our this particular lecture, which we'll try to understand that if the property is, if the person has a property and that is an immovable property. Here we are talking about immovable property and also movable property. That is also we'll be going to discuss. First, we are initially discussing about the immovable properties. Then how the person will be able to figure out that this property has to be divided in what manner. Everything has been answered under the Hindu Succession Act of 1956. Okay. So, and that type of succession is known as intestate succession. If there would have been a will present, then it is known as testamentary succession. When a will is present, the property will obviously be given to the person to whom the interest has been allocated under the will. But if the will is not present, then it is the codified law of the Hindu Succession Act that will come into play. So let's try to understand and let's overview what exactly the Hindu Succession Act of 1956. The Hindu Succession Act of 1956 is talking about the succession, and that is intestate succession. Let's try to understand. So this is your chapter number 1, preliminary, which is talking about the short title and extent, to what extent, to which territorial region this act is going to extend, what is its title, to whom it is application, what is the definitions and interpretations that will be there, the overriding effect. So if you have observed clearly and carefully, there is a word which is known as SADO. And why am I mentioning SADO here? Because S stands for short title, A stands for application, D stands for definition, and O stands for overriding effect. And if you can correlate with Hindu Marriage Act of 1955, the same 4 definitions that has been there under SADO has been there under the Hindu Marriage Act also. So these 4 sections that we have studied under the Hindu Marriage Act is perhaps exactly the same in regards to the Hindu Succession Act also. Only the difference is the short title has been changed. Here it is known as the Hindu Succession Act. There it is known as Hindu Marriage Act. And then these are the principles. That act does not apply to certain properties. Okay, that we'll be studying. Devolution of interest in co-parsoner property. What is co-parsoner? We'll try to understand that. Devolution of interest in the property of a tag word, Kurtum, and this one. General rules of succession in case of males. This is an important section. It is perhaps the most important section when you talk about how the succession will take place if, for example, a case of X that we have discussed, he is what? Male. So when you talk about succession, when you talk about males as such, they have a different rules for the succession. And when you talk about Y or woman, that they have a different rules for succession. Then order of succession among heirs in the schedule. This is what an important rule that we are going to study, that if a person has died intestate, meaning which without leaving a will, then how the property will be divided, that is what going to be used. What is that? That is what we are going to study. Then distribution of property among higher in class first. Now what is class first and what is class 2? That is what we are going to study in our upcoming lecture. This is just an overview for you people to understand that this intestate succession, if you can see on the above, you can see what exactly has been mentioned, that intestate succession, and that is chapter 2, and which means that if you talk about intestate, meaning without will. So if there is without will, then what would be the grounds and how the things would be divided? That is something that we're going to study. And distribution of property among higher in class 2 schedule. Okay. Then order of succession among the agnates and cognates. What exactly is agnates? What exactly is cognates? That is also we're going to study. Then computation of degree. Okay. Then what exactly is a degree? That is also we're going to study. Properties of female. In the same way, I just informed you that under section 8, we were talking about rules for males succession. In the same way, in the section 15, you will find mention of female Hindus. Okay. Then the same way we would be studying about the order of succession of and manner of distribution among the females. Then special provisions regarding to these two communities. Then we will obviously be understanding other general principles, which is very important. What is full blood preferred over half blood? So we have studied full blood, we have studied half blood also. So we will be seeing that full blood will be given preference over the half blood. And mode of succession of 2 or more is higher. If there are 2 people, let's take an example. This is X nephew, and then there is Y who is said to be uncle. Nephew is of 20 years of age, uncle is of 18 years of age. So there is a complication here. Okay, nephew is elder, uncle is younger, and both of them dies together. Both of them dies together. So the question is whether nephew will succeed uncle, meaning which the property will be given from nephew to uncle, or whether uncle will succeed nephew. So whether it will be dependent over the age or whether it will be dependent over the relation, that is what we will be studying under this section 19. Then right of child in a womb, when the child is unborn, and if whether he will get rights or not, that is also we're going to study. Presumption of cases in simultaneous death, that is also we have just informed you. This is you can understand in the same particular manner. Then preferential right to acquire property in certain cases, that is not what we are going to study. And murders are disqualified in succession, that is a clear thing. Converts, descendants disqualified, meaning which there is a person X who happened to be a Hindu and he had a son and he got converted into Christianity. Okay. Christianity. Now whether he will acquire the property, and he also had one son. Okay. So X being a Hindu, he has a son, and the son also had one more son, that is sons. Now, if the demise of X happens and the property is intestate, then XS, even though he has been converted into Christianity, he will still be getting the property. But that property shall not be entitled and provided to the descendants of a convert. So since he has converted to Christianity, now his son is not allowed to inherit the property of X, who happens to be the ancestral property of S. This is something that we have studied. Succession when higher disqualified, that is what we are going to study also, and disease, defects, and not to qualify. This is something that we are going to study. And then obviously last is failures of higher. Now let's take an example. There is a person X and he has no relatives as such. Neither mother, nor father, nor brother, nor relative, not a daughter, son, anything, etc. Now, how this person, to whom this property, and he still owns a property of A, B, and C that we have discussed in the starting, then to whom this property will be given? The property shall be given to the government in that particular organization, and that is what is known as cheat. That if none of the survivors or none of the heirs are present in regards to X, then the property will directly be transferred to the government, and that is what we have studied. And when you talk about testamentary succession, I have just informed you, it is about the will. And then they have talked about that how the will needs to be created and everything. And then they will be scheduled that we're going to study. So first, let's try to understand section 30, because it is something which is obviously we have studied so far, and we have understood that it is what is testamentary succession, and it is important to you to see the relevant section also, because it is only one section which talks about testamentary succession, and that is what we are going to study in today's lecture. Okay, after this we have completed testamentary succession, so at least one portion of your succession act will be over, that is testamentary, and then intestate we are going to discuss. So let's see what exactly it is saying. It is saying that any Hindu may dispose of by will or by other testamentary disposition any property which is capable of being so disposed of by him or by her in accordance with the provisions of the Indian Succession Act of 1925 or any other law for the time being in force. Okay, this is clear. The interest of male Hindu in the Mitaksha Kuparshnari, or the interest of that is something that is not relevant for you. So in accordance with the provisions of the Indian Succession Act of 1925. So the Indian Succession Act of 1925 clearly gives this authority to the person, that if the person is have a free consent, he is making the will free of his own mind, and even if he provides his property to anyone, to a stranger also, and that will is examined and witnessed by two people, then that particular will be considered to be the valid proof of testamentary succession. Okay, so that is what is all about testamentary succession. And from tomorrow onwards, we are going to start with our succession in regards to Hindu male, and then we'll study about succession with regards to Hindu female, when the testamentary succession is not possible, meaning which the person has died without leaving behind any will, and that is why it is important to understand these provisions. We will start with the definitions and interpretations. We have already covered a majority of portion when we studied about first and second article, but in the third one, we are going to study about the definitions. What exactly is agnates? What exactly is cognates? The expression Hindu in an provision that has already been studied. And then what exactly is Aliyastana laws? Also, we will study what exactly is cognates, what exactly is customs and usages. We have already studied custom and usages. Well, we just give a quick revision. And that is full blood, what is half blood, and uterine blood. The two persons are said to be in half blood, two persons are said to be uterine blood. And then what is ancestors and ancestress? What is a higher? What is intestate? Dies intestate respect of property of which she is not made testamentary disposition capable of taking effect. Then this is what we are going to study in our upcoming lecture series, which we will be studying about intestate succession. Testamentary succession, I've informed you. We'll be covering the intestate succession, where which we will try to understand that if the person has died, leaving behind no will as such, then who also ever are the co-personers or the survivors of that particular Hindu, how that property will be segregated among those people. That is what we are going to study in our upcoming lectures. So I suppose you were able to understand that what exactly is the need of the Hindu Succession Act of 1926, what exactly is it going to teach us, and what exactly is going to convey to us. That if a person dies without making a will, then how the property will be segregated among the survivors. It can be through will, that is obviously testamentary succession that we have already studied, but we are going to study the testamentary, that is the intestate succession, in our upcoming lecture series. So I would thank you all again for being present in this particular lecture series. In this particular lecture series, we have talked very important aspects. We have given an overview about the Hindu Succession Act. We have talked about what is the difference between testamentary and intestate succession, which we have completed the testamentary succession. And now we are left with intestate succession. Apart from the syllabus, apart from the principles and the concept that we are studying, in the earlier phase of this particular series only, in this particular lecture only, I have informed you the importance about the preparation pattern and the methodology a person should follow in order to make sure that they are able to qualify the examination with flying colors. So I suppose you will be adhering to those principles. You will be consistently studying and consistently reading so that you become very much efficient, and so you are able to tackle the questions in a very crisp, clear and precise manner, and you are able to apply with immediate effect once you read the passages that what exactly is the principle that we are referring to, and then you are marking the answers correctly. With this, I would again like to thank you all for being present in this particular lecture series. Let's meet in the next video and let's try to understand what exactly is intestate succession. Till then, thank you so much guys. Bye bye and take care.